Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Probably going to notice some changes in this video, just some of the ways that things have been done are a little different. I'm experimenting with adding some different software into the mix to try to make this a little bit cleaner and look a little bit better and give a better feel to what it is that I'm doing here. I would really appreciate your comments about whether or not you like the way I've done this. In particularly when I'm talking about a case or an opinion, I'm going to try to just have myself down in the bottom corner with the opinion up, and we'll just sort of go through it together that way, instead of leaving me off camera the way I have been in the past, which isn't to say that I like the idea of being on camera. It's just mostly to try and make it look a little bit like the way other people do things. And maybe that's not good. I don't know. Whatever you think, let me know what you think about the changes. Today, we're going to talk about an interesting case from the city of New York, the Second Circuit. And it involves something that I think is of interest to everybody who works for hourly wages. And if you know somebody who might benefit from this information, please pass it along. In fact, you might even ask them to subscribe. They might learn something here. But we're going to talk about the city of New York versus these emergency medical technicians. I think it's very interesting that cities sometimes have policies that say one thing, but the employer's supervisors tell the workers, no, that doesn't apply to you, or something similar to that, which I think is what happened here. Let's start with the proposition that everybody who works and does work and gets paid for it has a right to receive their wages and to have them paid in accordance with the federal law. Now, there are two categories of workers. There are exempt and non-exempt workers. Exempt workers are those that are paid a salary. So if you make $25,000 a year at Burger Doodle, and that's what they pay you to be an assistant manager, which in many cases means fry cook, well, that's a salary, and they can require you to work 60 hours a week if they want to. You don't have to do that. You can go find a job somewhere else. But a salaried employee generally has a little bit more authority and experience than a non-salaried employee. And there are tests to determine, and the government uses tests to determine whether someone is purposefully misclassified as an exempt employee and paid a de minimis salary in order to avoid having to pay them overtime work. So just because you're classified as exempt doesn't necessarily mean that you are exempt. It just may mean that your employer doesn't want to pay you fairly. If you work for an hourly wage, you are non-exempt, and there are certain requirements that the government has laid down that must be met by your employer. And we'll talk about those here in a little bit. But first, let's dive into the case and see what it says. So this is the interesting case involving the paramedics from the city of New York. And basically what they alleged was that the city of New York violated the Fair Labor Standards Act by requiring them to perform work before and after their shifts without paying them for that work unless the plaintiff specifically requested overtime compensation from the city. A jury agreed following a 12-day trial. The city now appeals, and it raises 4 points. The jury's liability verdict cannot stand because the plaintiffs failed to request overtime pay for the work at issue. The jury's willfulness finding was not supported by the evidence, and due to an erroneous instruction, the jury failed to make the necessary factual finding regarding the calculation of damages. And then finally, the district court forbade the jury from considering whether one component of plaintiff's post-shift work was de minimis and therefore non-compensable. The city accordingly asks that we reverse the jury's verdict or remand for a new trial. We decline to do so and affirm in toto. The city's principal argument on appeal is it cannot be held liable for the unpaid overtime because it affords an opportunity to report overtime work, and since plaintiffs failed to report the work at issue, the city did not know that any plaintiff was being shortchanged. An employer must pay for all work it knows about or requires, even if the employee doesn't specifically request compensation. Allowing or even requiring an employee to report overtime work doesn't absolve the employer from paying for work that they know about. Moreover, we now hold that whether an employer knows an employee is not being paid is irrelevant to liability under the Fair Labor Standards Act. The record supports the jury's finding the city had a policy or practice of requiring plaintiffs to perform work before and after their shifts, and we uphold the jury's verdict that the city violated the FLSA by not compensating for that work. Nor do the city's other arguments require reversal or vacator. First, the jury's willfulness finding is adequately supported by the evidence. The city knew the plaintiffs were performing unreported extra shift work, yet they took no action to remedy that situation. The city complains the district court should have, but did not instruct the jury that plaintiffs had to show that 100% of the time included in plaintiff's damages calculation was FLSA compensable. We conclude this wasn't fatal because such a showing would have been impossible in this case. And the plaintiffs put forward an adequate approximation that showed the amount of their uncompensated work as a matter of just and reasonable inference. Finally, the city was not entitled to have the jury determine whether one certain component of plaintiff's work was de minimis, an issue decided against the city at summary judgment. The de minimis inquiry generally applies to the claimed work as a whole and not to each task the employer requires. So remand is inappropriate because no reasonable jury could have found for the city under any permissible framing of the de minimis inquiry. So here is a page on the web that is the U.S. Department of Labor. It's the handy reference guide to the Fair Labor Standards Act. And on this website, you can find all kinds of good information that will be helpful to you. For example, it gives you the basic wage standards. Covered non-exempt workers are entitled to a minimum wage of $7.25 an hour, which seems ridiculously low. Special provisions apply in other places, but basically, wages required by the FLSA are due on the regular payday for the pay period required. Deductions made from wages for such items as cash or merchandise shortages, employer-required uniforms, and tools of the trade are not legal to the extent that they reduce the wages of the employee below the minimum rate required by FLSA or reduce the amount of overtime pay due under the FLSA. So that's really interesting, and I think that's something that most workers don't know. If you go to your employer and your employer says, okay, we're going to pay you $15 an hour to work here at Burger Doodle, and when you're flipping your burgers, you're going to have to wear the bright red Burger Doodle outfit. And by the way, it's a polo shirt that costs $15. And we'll deduct that from your first paycheck. Well, if the deduction of that from the first paycheck winds up reducing it below the minimum wage level of $7.25 per hour, it's illegal. They can't get by with that. The Fair Labor Standards Act has a lot of interesting components to it, but it also has some things that probably ought to be in there that are not. For example, it doesn't require vacation, holiday, severance, or sick pay. Meal or rest periods, holidays off, or vacations are not included. Premium pay for weekend or holiday work, like shift differentials, those aren't part of the FLSA. And pay raises or fringe benefits and discharge notices are not provided for under the Fair Labor Standards Act. Now, your state may have specific law on these topics. For example, in Missouri, there is something called a service letter, I think is actually what it's called, that the employer has to tell you the reason you were discharged and whether or not you're eligible for rehire. And you make a formal request for that with a certified letter. You have to get back a letter that satisfies that obligation. And if you don't, well, then your employer can be liable for a lot of other damages that are under that statute. So one thing that I think most people don't do is they don't go and read the poster that's at the office that tells them what their rights are under all of these federal and state laws. If they did that, they would be much better positioned to complain about things that are not right under the Fair Labor Standards Act. And if you get fired for complaining about Fair Labor Standards Act, you have an additional cause of action. And I want to just point out that there is a group of lawyers called the National Employment Lawyers Association that represents plaintiffs in these kinds of lawsuits, and also in wrongful termination and that sort of thing. I would urge you, if you ever have an employment issue, to go and see them and talk to them and find out what they can do for you. So the city got burned principally because it simply failed to take into consideration the fact that just because it had an automated timekeeping system didn't mean that the timekeeping system was keeping accurate time. And of course, all of the people in these fire departments and station houses knew exactly what was happening. Everybody who was in a supervisory role knew that it takes the paramedics a little while to get into their uniform. It takes them a little while to get all of their bags and equipment laid out. You've got a bag that's got all kinds of medical supplies in it. You've got another box that has drugs in it that you have to check and make sure that all of the cardiac drugs are not out of date. Working on an ambulance is quite the extensive experience, and you have to be ready to do it, and you have to be ready to jump at a moment's notice. And because of that, even though these employees have an 8-hour shift where they may not necessarily be doing patient care the full 8 hours, they have to get there in an ambulance. The ambulances get hit all the time by other passing cars because people don't pay any attention whatsoever to emergency vehicles anymore, at least so it seems. And in addition to that, there are, they may get called out to go take care of somebody who's had a fall, and the call is actually somebody who wants to do them harm, rip off their drugs, whatever. Long and short of it is, it's a terrible job to do in a city like New York, and if you're going to do it, you sure as heck ought to get paid for it in the way that you're supposed to get paid for it. And that's not what happened here. So that's what I have for you today. It's a little shorter than usual, but today is my wife's 63rd birthday. And for that very reason, I am going to take her out to dinner. I'm going to take her daughter and her husband, well, her daughter's husband, because I'm her husband. I guess I'm taking her husband too. And all the grandkids, and we're going to go eat and get something to eat at Walk-On's tonight and have a little bit of birthday cake. Everybody will have a good time. So as you watch this today, I want you to think about the most wonderful woman in the world, the woman who made me the man that I am today, the woman who taught me to be kind. So thank you so much for watching. Have a marvelous day. Come join me down here at the beach again next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.